Good evening, ladies and gentlemen. Thank you very much for coming for this special edition of the Great Cases series, which is organized in collaboration with the India International Centre and the Vidhi Centre for Legal Policy. My name is Arghya Sengupta, and I'm the research director. And it's a really momentous day that we are meeting because it marks the end. It actually doesn't mark the end. It marks the last working day of the tenure of Chief Justice of India, D.Y. Chandrachud. D.Y. Chandrachud had his last working day in the Supreme Court today and retires on Sunday. His statements in the last month, both in the context of Ayodhya as well as inviting the Prime Minister home for Ganesh Puja, have generated a lot of controversy and criticism. But that cannot be the sum and substance of his tenure, both as a Supreme Court judge, the Chief Justice, as well as a person who has been in a part of the legal fraternity for over 4 decades. So anyone who knows him knows that it's very difficult to put him in such a neat straitjacket. There are various shades to his personality, and he contains multitudes, some of which may be agreeable to some, and some of which less so. And we hope to unpack that over the course of our discussion today. There are particularly 3 aspects that we want to touch upon. There is Chandrachud, the administrator, widely seen as patient, sympathetic, with great plans to build judicial capacity. How has he done on this front? Then there is Chandrachud, the judge. He has operated at a level that few other judges have and disposed of a number of cases with a very exceptionally high quality of reasoning. Equally, as I've written today, at key moments his reasoning has faltered, and so we want to discuss those. And then there is Chandrachud the man, the highly successful lawyer in Bombay, the much loved judge. A lot is known about his personal life, much more than many other judges. And so how do we see Chandrachud the man? And so he leaves behind a very complex legacy. And I want to make it clear to everybody present today that this is not a session to either bash the Chief Justice of India or to extol his virtues. We are a legal think tank, and the India International Centre is the premier centre for thought and culture in the city. And so this is a discussion true to the ethos of both these organizations that will go into Justice Chandrachud and try to unpack what his tenure has meant for the Indian judiciary and what we have going forward. And to do that today, I'm delighted to be joined by the immediate right, Justice R.C. Chavan. Justice Chavan is a former judge of the Bombay High Court, and more recently he was the vice chairperson of the E-Committee of the Supreme Court, working very closely with 4 Chief Justices, including Justice Chandrachud. To his right is Maja Daruwala. Maja Daruwala has worn many hats, and most recently she is the chief editor of the India Justice Report, which is a report that documents the state of India's justice system and its capacity to deliver justice. And she's really been a pillar in the world of NGOs in Delhi and India. And to the far right is Mr. Raju Ramachandran, senior advocate of the Supreme Court of India and one of its finest senior advocates, who I knew for the first time because of his wonderful book on the basic structure doctrine, which hasn't made news during the course of this Chief Justice's tenure as it had a little bit previously. I'm delighted to welcome all of them and all of you today. So to just set things in context, in terms of what Justice Chandrachud's tenure has been like, we thought that it would be good to start with some numbers. To unpack Justice Chandrachud's legacy in terms of data, we have a team at the Vidhi Centre, the Jaldi initiative, the Justice Access and Lowering Delays initiative, which has put together a short presentation on Justice Chandrachud's tenure in numbers. So I request Jyotika Randhawa, a research fellow at Jaldi, to make this short presentation, which will be the launch pad for the discussion that follows. Jyotika.
Thank you so much, Arghya. Good evening, all. As Chief Justice Chandrachud's tenure draws to a close, we are gathered here to reflect on his time in office. This presentation will therefore use data to understand how the Supreme Court functioned in his leadership and the impact the outgoing CJI has had on the court. Chief Justice Chandrachud assumed office in 2022 amid great anticipation. With a total of 732 days in office, his tenure extends beyond the average of 550 days. For some perspective, amongst the last CJIs, Justice Bobde had the longest tenure, which still fell 200 days short of Chief Justice Chandrachud's tenure. From the next 7 CJIs, except for Justice Daruwala, all other CJIs will be serving a tenure much shorter than Chief Justice Chandrachud. This is to say that Chief Justice Chandrachud had on his side the advantage of time. Time to understand the systemic issues that plague the judiciary, time to drive and oversee long-lasting reforms, and time to increase transparency, accountability, and efficiency. It is with this lens that we will deep dive into the numbers pertaining to Chief Justice Chandrachud's tenure. When CJI Chandrachud assumed office, he inherited a backlog of 69,781 cases. Since then, there has been an 18% increase in pendency, leading to an all-time high of 82,500 cases. While the figure may seem alarming, context is key. For one, since November 2022, the manner in which the Supreme Court calculates the pendency has changed to now include miscellaneous applications as well as unregistered cases, which was not the case earlier, hence the bloated figure. But more importantly, Chief Justice Chandrachud inherited a judiciary that was still reeling from the pandemic. Looking at the visualization here, we can see that the pendency at the Supreme Court has steadily increased over the years, with a marked increase between 2020 to 2022, which is attributable to the pandemic. In fact, if one looks closely enough, one can see that the increase in pendency during Justice Chandrachud's time has been the lowest since 2019, which was pre-pandemic. Therefore, the unprecedented pendency must also be understood in the context of the backlog that is being carried forward from the pandemic period. It is, however, also true that during Chief Justice Chandrachud's time, Supreme Court has not been able to keep up with the rate of the institution. For instance, disposal has, as can be seen from the graph, disposal has significantly increased since 2020, but so has the institution. In fact, the case clearance rate has dropped from 108% in 2022 to 99% in 2023 and further 97% in 2024. What this shows is that while the rate of increase of pendency has leveled to that of pre-pandemic levels, Chief Justice Chandrachud still leaves the Supreme Court with a caseload higher than when he began his tenure. Moving on to judgments. As the CJI, Chief Justice Chandrachud was part of 189 benches, out of which he has authored judgments in 92 cases. That is approximately half of the cases in which he was part of the bench. The numbers are significantly higher than his predecessors. For instance, under Justice UU Lalit, Justice UU Lalit authored 10% of the judgment in the cases in which he was part of the bench. For Justice N.V. Ramana, the figure is 20%. For Justice Bobde, it is 6%. And Justice Ranjan Gogoi authored 11% of the judgments in cases in which he was part of the bench. When it comes to constitution benches, perhaps one of the most talked about aspects of Chief Justice Chandrachud's tenure, the CJI was part of the bench in 7 out of the 30 cases disposed during his tenure. In this, he authored judgments in 14 cases, that is 82% of the constitution bench cases. These include the judgment pertaining to the abrogation of Article 370 of the Constitution and the judgment striking down the electoral bond scheme as unconstitutional. Only in 3 cases did the CJI not author the judgment despite being a part of the bench. Along with contribution to constitutional jurisprudence, the Chief Justice made significant contribution to the functioning of the Constitution benches. For instance, the Jaldi Initiative's Constitution Bench Pendency Portal had highlighted that for the most part of 2022, there was not a single active Constitution bench functioning. However, during Justice Chandrachud's tenure, at least one Constitution bench was active and hearing matters throughout. This was made possible because of the systemic changes brought in by the CJI. For instance, appointing nodal counsels so that they can coordinate between the advocates to obtain time estimates and provide timesheet to the court, using which the court rationed the time for oral arguments. To better understand the impact and document the impact of these changes, the Jaldi Initiative has put together the Constitution Bench Time Tracker. It is a one-of-its-kind repository that provides comprehensive analytical analysis of the time spent in Constitution Bench cases. The dataset constitutes of 23 cases that were live-streamed from September 27, 2022 to August 14, 2024. The data was collected using live-stream recordings, argument transcripts, and court data, and court orders. Analyzing the data, we found that during Chief Justice Chandrachud's tenure, 5 judge benches have on average taken 15.6 hours for completion of oral arguments. 7 judge benches have taken a relatively shorter time at 14.5 hours on average. And 9 judge benches have taken the longest time, the most time at 24.9 hours. It needs to be understood that Constitution bench cases require the simultaneous commitment of multiple judges. Therefore, in terms of judges' time, which is the most scarce resource, Constitution bench cases require 5, 7, and 9 times the duration of the case, depending on the bench composition. This is known as judicial time and is calculated by multiplying the case time with the number of judges on the bench. Therefore, the judicial time spent on cases during Chief Justice Chandrachud's tenure was on average for 5 judge benches, 78.2 hours, for 7 judge benches, 101 hours, and for 9 judge benches, understandably, 223 hours. While this may seem like a lot, it is important to understand that Constitution bench cases are extremely significant cases involving substantial questions of law. They lay down the law of the land and decide the collective and individual rights of the citizenry of the country. In contrast, the court spends a total of 306 hours per week on admission matters, with nearly 89% of these cases getting rejected. Therefore, the time spent on Constitution bench cases is not only expected, but also warranted, given the high significance of these cases. Overall, we can see that most of the Constitution bench cases took less than 20 hours of hearing. 7 of these cases took even less than 10 hours of hearing, out of which one case in particular, that is the High Court Bar Association of Allahabad versus State of UP, got completed in a record time of 1.3 hours. On the other end of the spectrum is the Article 370 case, which took about 59 hours of hearing to get completed. Again, while this may seem excessive, it is important to understand that the case involved admittedly complex questions of law being argued by 37 lawyers over a span of 16 days. To conclude, during Chief Justice Chandrachud's tenure, pendency at the Supreme Court stabilized but did not decrease. Pendency of Constitution bench cases, however, saw a marked reduction because of the court's intensive efforts to continuously prioritize and list these cases. But perhaps what Chief Justice Chandrachud will be most remembered for are the many landmark judgments penned by him that shaped the constitutional jurisprudence of the country. Thank you.
Thank you very much, Jyotika, for giving us that overview. I think it does set things in context in terms of what has and has not been achieved in terms of numbers, because we tend to get carried away otherwise by recent events. So thank you very much for setting that context. I'll turn now to Mr. Ramachandran. Mr. Ramachandran, your opening remarks on Justice Chandrachud, who you've seen very closely, both first as a lawyer and also from the time he was a judge in the Supreme Court. Mr. Ramachandran.
Thank you, Argo. And if you have a bell, please feel free to ring the bell, because time management is something which we all ought to practice. And when we discuss reforms in the court, that's going to be one of my suggestions. So please stop me when my 5 minutes are over. Now, you said to talk about Justice Chandrachud, the man. So first, a personal disclosure. Of course, lawyers and judges are part of the same fraternity. Many lawyers know...
Can you just go a little closer to the mic?
Yes, sorry. Let me repeat. Lawyers, I'm making a disclosure first. Lawyers and judges, of course, are part of the same fraternity. Many lawyers know many other lawyers. Many judges know many judges. Many lawyers know many judges. Many judges know many lawyers. But beyond that, I have a closer personal connection, which I must disclose, because I have known Justice Chandrachud from the day he joined the bar, and known him well because his father-in-law, in whose chambers he started, late Dr. Chitale, was my late wife's senior also. So I've known him from then. And now if you know someone well, there are 2 or 3 kinds of reactions which you may have. One is intense prejudice. One is strict neutrality. Third is you have a soft corner. So let me confess at the outset, I have a soft corner, which doesn't mean that he has not done things which have disappointed me. There have been disappointments, but in this forum we are discussing something larger than either a Ganesh Puja or invoking a deity or appearing in saffron clothes at a temple in Gujarat. These are matters of criticism at a different level. But let us look at him as a person. I have known him to be a kind-hearted humanist. He has seen life in all its facets. He has braved personal tragedy as a young judge. He is empathetic in his personal life, as we know that he has 2 foster daughters. And therefore, he is, in my view, a compassionate person. Now, as a judge, what I find noteworthy is that he has set standards of judgment writing. So that's, apart from individual cases, how judgments of superior courts are to be structured and written in terms of logic, in terms of analysis, in terms of lucidity, in terms of a user-friendly reading. Standards which he has set in judgment writing, I think, will be emulated in times to come by all judges who strive towards excellence. His contributions particularly, I don't want to go into a litany of cases in the short time which is available. I would try, and let us also remember, we are not just judging Chief Justice Chandrachud, we are judging Justice Chandrachud. When I say judging, it's because it is always said the bar is the judge of judges. And so if we are being judgmental here, it's legitimate here. So we are looking at an 8-year tenure in the Supreme Court, not 2 years as Chief Justice of India. And I would say that the major contributions of Justice and later Chief Justice Chandrachud are in the area of privacy, individual dignity and constitutional morality, which would comprehend cases like Puttaswamy, Navtej Johar, Sabarimala. Sabarimala is particularly noteworthy because in his separate judgment, he has developed the concept and has found possibilities in the concept of untouchability, Article 17, which were not hitherto explored. That notions of impurity attach to a menstruating woman is a facet of untouchability, is an area of law which I think will be carried forward in the years to come. Then similarly, in the same-sex marriage case, though ultimately the outcome was disappointing, nevertheless, the fact that in a minority, he said civil unions ought to be recognized is an extension of his understanding of the concept of privacy and dignity starting from his interpretation in Puttaswamy.
Ramachandran, one more minute. 1 minute.
1 minute.
Yes.
One more minute, right. Right to information, electoral reforms. Federalism, various aspects of federalism. The GNCTD cases and a couple of taxation cases. And then what is important is free speech. Again, the cases are well known. And he has been able to overrule some long-standing precedents which today don't stand the test of time, including corrupt legislators case, Sita Soren, today's AMU judgment. These are matters, and in Puttaswamy, overruling ADM Jabalpur and holding his own father's judgment to be wrong. So, concluding in the remaining 30 seconds, let me just say this. You know, the famous journalist, someone whom I had high regard for, B.G. Verghese, the title of his autobiography was First Draft. Why first draft? Because he said journalism is the first draft of history. Now, today's controversies on various other aspects, in today's discourse, not just in journalism, is just the first draft of history. History will be kinder to me, said Manmohan Singh. The same thing will be said of Justice Chandrachud some years later, and in my view, Justice Chandrachud will rank as one of the finest judges of the Supreme Court. Thank you.
Thank you very much, Mr. Ramachandran. I think it's very clear from your brief opening remarks that Justice Chandrachud has left a deep imprint on the development of law in India, and I think we can get into it in more detail in the discussion in terms of what kind of imprint it was, and certainly some questions there as well. I turn to now Justice Chavan, who has seen him as a colleague, who in the Bombay High Court has also worked with him very closely when, in his administrative capacity, when he was, Justice Chandrachud was the chairperson and Justice Chavan was the vice chairperson of the E-Committee. I have always known Justice Chavan to be free and frank, so I'm hoping he will be free and frank today as well. Justice Chavan.
Thank you, Arghya. In 2013, when I left the Bombay High Court, Justice Chandrachud was the senior most judge of Bombay High Court. And he spoke at my farewell. Even in my wildest dreams, I never thought that I would have an occasion to speak about Justice Chandrachud on his last day in the court. It's not a farewell speech. I can't, because I'm not a part of people who are giving him farewell. But I thank Vidhi and Arghya, Dr. Arghya Sengupta, for giving me this opportunity of sharing a few thoughts about Justice Chandrachud's contribution. Dr. Sengupta has written an article in Times of India, which has appeared in Times Today. He has described Justice Chandrachud aptly, appropriately, as ambitious celebrity. That describes, in fact, everything about Justice Chandrachud. there are some youngsters here and they will please realize the load of expectations which Justice Chandrachud carried when he became a judge of Bombay High Court. He is son of India's largest serving Chief Justice and also a very eminent judge. And he became a judge. Justice Chandrachud, Dr. Chandrachud became a judge at the age of 41. So therefore, from day one, people looked at him with great expectations. He was looked upon as the future Chief Justice of India from day one. He was treated as such in the Bombay High Court. Naturally, there was a huge pressure on him to perform, just as children have when they have got parents with excellent academic or excellent performance, and they also perform well. So once you stand first in your class, you are expected to keep on standing first for all the remaining years. Naturally, he was extremely careful because one slip of tongue, one symptom of judge's disease, and the dream would have shattered. In the High Court, he sat mostly with the Chief Justices. This gave Chief Justices who were from other states a chance to know who is who and what is what in the Bombay High Court from a dependable colleague. He was a source of strength for all the incoming Chief Justices from outside. Occasionally, he sat with the senior most judges till he himself started heading the bench. Generally, he avoided skirmishes, towed the seniors' line, and seniors too were persuaded to heed his views, aware of his potential. It's certainly not that he did not want to shape the law or had no ideas about areas in which law needed to be changed. As Shri Ramachandran has just now told us, he had his views on homosexuality, LGBTQ, marriages, adultery, privacy, which he later articulated in his judgments in the Supreme Court. He did not even float any such ideas or sow the seeds of his thought in Bombay High Court judgments to avoid stirring hornet's nest or burning the boats. He chose to reserve his gunpowder till he was actually in a position to deliver, to make a dent. So his decisions in the Bombay High Court conformed to the traditional conservative thought. He is on record as having said that Justice Ranjana Desai's guidance in handling criminal matters was invaluable. This is humility. See the man, he acknowledges that he learned something from a colleague. Though the unruly executive at times needed to be tamed, he stuck to the canons of only examining decision-making process rather than the results. He was cautious and hesitant to embark upon voyages on uncharted seas. As his judgments of Supreme Court eclipse his judicial work in the Bombay High Court, I would not spend time on it, except to mention a judgment in the Bombay High Court on the Industrial Disputes Act, because he did not deal with many such matters. Sitting with Justice Khande Parkar, he wrote a judgment in Sylvester versus Workman. The question of appropriate government was in fact not a question at all. The Industrial Tribunal as well as a single judge had consistently held that appropriate government was the central government. Here, the termination was faulted by the courts below, that is a single judge and the Industrial Tribunal, because the employer had not made out a case for dispensing with disciplinary inquiry and had not made out grounds for dismissal. The tribunal as well as the single judge found that employer failed to avail opportunity to tender evidence about misconduct. Justice Chandrachud, who wrote the judgment for the bench, observed that even before this court in appeal, it has not been submission of the employer that there were valid or justifiable reasons for dispensing with inquiry or circumstances were such that inquiry was not possible. But then in para 24, he went on to hold that we are with respect of the view that single judge was in error in not accepting the plea of the employer and in declining to remand the proceedings to prove misconduct. And the matter was remanded. The employee had been sacked in 86. In 2007, the matter was remanded. Now, it is here that we And we can imagine how many more years it would take for the matter to come back, bounce back, or the employee to get the relief. Now, it is here that we remember the Gang of Four. I mention Gang of Four because recently Justice Nagaratna and Justice Dhugia, had an occasion to comment about Justice Chandrachud's reference to Krishna Iyer. The Gang of Four, that is Krishna Iyer, Bhagwati, Chinnappa Reddy and
D.A. Desai.
D.A. Desai. Yes. They injected life in the dead letter of law. Now, even in this case, the bench could have said that, well, 21 years have been spent and therefore let us do something to help the employee at least to stand on his feet. Anyway, but then Justice Chandrachud was conformist. He conformed to the letter of law and did not take a jump to join the Gang of Four.
So one more minute.
Yeah. So, on the bench, he was courteous to a fault. He never ordered Anrugi advocates to shut up or sit down, unlike something which he did in the Supreme Court in the last legs of his work. He would say, thank you, that means you sit down now. So, there was, in the last innings or last overs of his innings, why he behaved like this. You can understand a cricketer playing a match. Initial overs, he's trying to settle down. Once he settles down, he plays a steady game. And in the last overs, he hits shots indiscriminately left and right. And possibly that is where the batter, to use expression, vocabulary of Justice Chandrachud, not a batsman, where a batter gets battered. So it's unfortunate, but he is and has been a great judge, and he has done a lot of good things. On administrative side, he has tried to do many things. Unfortunately, they could not be completed because, as the statistics shows, he wrote a lot of judgments, and therefore, maybe he did not have enough time to look into improvement of the judiciary. Thank you, Arghya, for giving me this opportunity.
Thank you very much, Justice Chavan. I think this is now set up quite nicely. This is what we were looking for, because this is a perspective from Bombay and how he's been in the Bombay High Court. A very important, what was it, about 12 years on the bench, something like that. 12 years on the bench in the Bombay High Court. Thank you very much. Now we zoom out a little bit to bring Maja into the picture. Maja has been working on the capacity of the justice system. And now, Maja, over to you in terms of how the justice system has fared over the course of the last few years when Justice Chandrachud has been at the helm. Maja.
Thank you so much, Arghya, and it's an honor to be with Raju and with Justice Chauhan, and thank you for inviting me, Arghya. I don't pretend to make any kind of evaluation. I would not dream of that. But I will go and talk about it's hard to bring the whole thing into a frame because not everything that Justice Chandrachud did was actually initiated by him. Some of it was going forward anyway. Others of it was encouraged by him. So as the chief of an apex institution tasked with the stewardship of administration of justice across India, this meant attempting to improve efficiency, accessibility, transparency, and diversity, and try to modernize judicial functioning, right? So these were the conceptual part. Then the practical pathway was emphasized with the use of technology, which was something that was encouraged, and also tweaking the administration to the amount that you really can change the administration in 2.5 years or 2 years and 3 months, of a system that is brought itself into a creaking halt. So how much can you really do? Radical overhaul was never a possibility. So you had to do it incrementally. Now, some focused initiatives which actually changed in practical terms how the court would be run, the Supreme Court would be run. And hopefully that will be an exemplar for the high courts and for the district courts, right? So some of them were, one of the things I should say is, yes, caseload increased, but did not increase as much as the lady who came from Jaldi, did not increase so much as normally in other times. So that says something about time management, initiation, and disposal. The digital case listing system and the notion of paperless courts with the help of any amount of technology meant that nearly 10,000 new cases digitally could be taken up by the registry, and over 15,000 petitions could be were streamlined during the months that happened. Then the Supreme Court's mobile app allowed law officers and government departments to track cases. Hybrid hearing at the Supreme Court of both in-person and virtual appearances. Reduced travel time and probably a great deal of costs for litigants. Then case mentioning processes were instituted so that urgent matters were heard more promptly, and specific days were dedicated to different categories. So you had a sort of semblance of case management being streamlined. The fact that constitutional cases were live streamed had a lot of resistance. There was always the chance of people grandstanding and, preening in front of the cameras, etc. And that will happen. But it also increases the accountability of the council for how they're using your money, how they're using your time. And so that in itself increases accountability. Then one of the interesting things that happened during his tenure was that there was this publication called the State of the Judiciary Report of 2023. This went beyond the annual report to talk about the deficiencies, the needs, the money, the budgets, the vacancies, all across the 3 levels. So that in itself is something that I hope will be continued and does not become one of these ad hoc things that some judge does and then the next one doesn't follow. So in terms of legal aid, by integrating some of the elements of legal aid services into the National Judicial Data Grid, which also was expanded and made more detailed during his tenure, you could get real-time information on case pendency and disposals and prioritization of urgent cases, especially those involving vulnerable individuals at risk of prolonged detention. So these are practical methods by which you actually make justice a little bit more accessible. Then there's an interesting thing that in the last few days we have seen President Murmu release 3 publications called Justice for the Nation, Reflections on 75 Years, Prisons in India, Mapping Prison Manuals, and Legal Aid Through Law Schools, which indicates to me a vision that was a little bit more futuristic. You're putting things in place, you're making ideas come forward. For instance, he talked about, in the last few days, I think, he emphasized the need for a national judicial service, standardization of curriculum, the training of judges, the fact that he created a handbook to indicate and guide judges about sexist language. Those kinds of things go a long way to signal, not only signaling, but then also giving practical tools to people who are struggling to be better, but don't have the words and don't have the leadership. And so the question, I think, of there may be so many controversies that we have touched upon, and they seem to overshadow some of the more quiet initiatives that can be taken by a judge. One of the things, a very practical thing, was to draw attention to the fact that he had Justice Ravindra Bhatt do an audit to see how can disabled people access the courts. And then he implemented some of the recommendations in the High Court that Justice Bhatt mentioned. And also now there will be the possibility of high courts and district courts doing the same. So I would say, since I have only one more minute to go towards this, on the ground, not much has changed. Even though lots and lots of new judges were appointed, more than, I think the first year 165 and the next year 110 to the high courts, the difference between the vacancies that were there before and are now is not so great. I think there's only a change of about 2 or 3%. Cases are still mounting up, etc. The difficulties of operationalizing anything from the highest level, from when you're talking from the pinnacle and you're looking down at this mess below, and making things happen in a radical way was never a possibility. But to the extent that you can write 95 judgments and then also the administration, look at the administration of the judgment, it is, whether it is amazing or whether it is ordinary or whether it is unremarkable, it was actually done. Now his tenure is over. The issue now is whether even the halting momentum in some of the areas that has been achieved in the last 2 years, whether amazing or unremarkable, will be carried forth at a steady pace or will fall prey to the ad hocism which is fueled by personality and baked into short-term leadership tenures. The next 2 judges who are going to come and take his place will have the same number of days, or very much the same number of days that he had. You have to go 5 judges down the line to have a long tenure. Yeah, and a long tenure can be as disastrous as it can be marvelous. So keeping all of these things in mind, there is a legacy if you want to see that legacy and if you want to take it forward. Or we can carry on as business as usual. Thank you.
Thanks very much, Maya. I think recent tenures of Chief Justices have shown that sometimes shorter tenures can be better than longer ones in terms of how much can be achieved. But I'll start this discussion with the question that you left us with, Maya, and I will put it to Justice Chavan. That there seems to be some momentum that has been developed in some directions, but as the data pointed out, that we have pendency that has increased, we have vacancies in the high courts that have increased. All of this, of course, cannot be attributed to a single individual, but the hope that I think people had at the beginning is perhaps somewhat people have been disappointed. So you worked with him very closely on digitization, on the E-Committee of the Supreme Court. And I want to ask you this, which Maya left with, that some of the initiatives that he took with virtual courts, live streaming, e-filing, do you think that enough has been done, that this is systemic, or do you think that this progress will be reversed, whether intentionally or otherwise?
I don't have any doubt that this will be taken further, because people have realized the necessity, the need of these initiatives. But then, given the pressures on his time, I suppose he has done very well. I only wished that this system which has been brought in force stabilizes and becomes a part of routine. Unfortunately, we have got high courts. High courts are administratively independent of the Supreme Court. Supreme Court has no business to supervise or administration of district judiciary. But then he could bring along many High Court Chief Justices in getting the reforms on proper pace. There's one thing, and you mentioned about the appointment of judges. See, just imagine a Chief Justice having a tenure of about 2 years, appointing more than 260 judges of the High Court. Now, this is not a joke. For each appointment, the Chief Justice will have to spend a lot of time. Otherwise, we have appointments of the type and then the Supreme Court blasts them openly in the court, like what happened with Punjab judge, Karnataka judge or Patna judge. So, therefore, appointments of High Court judges is a very serious matter, and Chief Justice has to spend a lot of time on that, apart from the writing judgments. Therefore, let us understand the pressure on his time when he did all this. As far as increasing pendency is concerned, I believe that we need to have more pendency. Increasing institution, increasing pendency doesn't mean that people have lost faith in the system. It shows that public confidence in the system is increasing. People will be coming to the courts. Therefore, there is nothing wrong. Compare our figures with the American figures of institution per person. We talk of per million population, judge ratio, etc. Find out the institution per million population in America. And then you realize that we are at a fraction, I suppose it is 0.17% of American institution. So I suppose what has been done is may not be adequate, but we are on proper track and we will go further.
So I'll take off from what Justice Chavan had said earlier and take that to Mr. Ramachandran, that from the day he was appointed to the High Court in Bombay, it seemed that he was destiny's child, almost destined to be the Chief Justice of India. And I think that there is a general feeling, and this is without getting into any particular incidents, that there is a general feeling that it's really the hope that people had in what he would do and could do, that hope perhaps has not been met. And I sense that amongst a lot of people, that when he came on, and particularly within the liberal establishment, that there would be much more that could be achieved than it has. So I wanted to ask you, and I wanted to use the marriage equality case as an example. Because here is a case, and this is something that Justice Chavan was also alluding to, that he's talking the talk, but when it comes to actually giving the remedy, it's not kind of going in that direction. And you've argued that case, and here was a person who got this case from various high courts. It was happily moving along at its own pace. It was brought to the Supreme Court. Everyone thought that this was an opportunity for marriage equality. And all the kind of dicta in his judgment seemed to point in that direction. But ultimately, as not only was marriage equality for LGBTQ persons denied, but it was also held that there is no right to marry under the Constitution, which I actually find fairly surprising. So I wanted to ask you that what happened there to Destiny's Child? Why is it that there is a feeling that his talk went in one direction, but the actual order went in some other direction?
Thank you, Arghya, for asking that question, because there was one more thing which I wanted to say in my initial presentation, but my time was up. But your question gives me a chance to make that point also. We are looking for the perfect judge. Now, the perfect judge doesn't exist, as the perfect lawyer doesn't exist, as the perfect journalist doesn't exist, as the perfect teacher doesn't exist. It is our inadequacy, our imperfections which make us want to have a hero. We are all people with inadequacies, and therefore there are bound to be disappointments. Now, with specific reference to the marriage equality case, since I was one of the counsel for one of the petitioners and we were unsuccessful, let me say objectively. First part, that is to interpret the Special Marriage Act in a gender-neutral way, where it said man, where it said woman, that it should be read as person, etc., would have been a stretch. It would have been a stretch. And let's remember, he constituted that bench with all good intentions, and as the master of the roster, he had the chance to pick his bench, and I think he couldn't have got a better bench than what he constituted. But then he faced resistance from within the bench itself. I agree. One, he went far enough to say civil unions must be recognized. But there is a disappointment, and I think a shortcoming in carrying forward his own understanding of law, where he said there's no fundamental right to marry. Now, if you remember, ADM Jabalpur, which he also affirmatively overruled, was based on what? On something inherent. The majority in ADM Jabalpur, articulated particularly by Chief Justice A.N. Ray at that time, was liberty is the gift of the law. Whereas Justice Khanna's dissent was that liberty inheres in every human person. And therefore, with the same logic and with what was said in the first love jihad case of Shafin Jahan, where it was said there is a right to marry. Right to marry is an inherent part of a human being's right to dignity and to found a family. So yes, that finding that there's no right to marry, that observation was egregiously wrong. All that one can say is that great judges also disappoint us. This was a big disappointment. There's no running away from it.
So I'll take that point to Maja. I know, Maja, you want to talk only about the capacity of the justice system, but it's not as if you cannot talk about other things. But I wanted to talk to you about the master of the roster question, because this is something that has created a lot of controversy since the press conference of 4 justices on the 12th of January 2018. Now, from that point of time, it has been asked as to whether really Chief Justices of India should be exercising this critical function on their own. Sorry, I don't know what this is. Maybe you could just switch it off. There's always that.
I'm so
Can some tech-savvy
Yeah, I think
youngster
she can.
please help?
No, you can just help.
Panelists
Just
to-
can you switch that
to
phone
switch
off?
off her phone.
I think it's.
Oh, good Lord.
Just
I'm
switch
so
off.
sorry. Tech savvy.
Yeah, it's done. She's done it.
Tech-savvy is closer at
Take it
hand.
and throw it out.
Maybe that's what we should do with the master of the roster concept as well. Take it and throw it out. But anyway, no, I wanted to, on a more serious note, there have been serious questions in terms of how cases are allocated to benches, and this is not something that has gone away during Justice Chandrachud's tenure, as in whether it is some bail matters going to a particular bench of the Supreme Court, whether it is, as Mr. Ramachandran said, how particular constitution benches are picked. This is an immense power that the Chief Justice of India wields in a court of 34 judges, and one that seems to be completely arbitrary. So I wanted to ask you, as we look ahead and Justice Khanna is taking over as the Chief Justice of India, do you think that this master of the roster system needs to change in terms of, do we need to look at alternatives, checks and balances, like it being taken by a group of judges, or some such alternative mechanism which will ensure greater public confidence?
I'm trying to answer this question without cynicism, and I'm not sure. Honestly, I'm not sure. I'm not a practicing lawyer, though I observe the courts very closely. I think the problem is much more systemic than who is master of the role. There needs, whatever you do, you're going to have at some stage someone who dictates the terms. You can call him the Prime Minister, you can call him the Chief Justice, you can call him the master of the roles. But we have come to such a stage where the whole court is so overburdened that litigation itself has become a game, a chance. Who has the face? Who in the small community can command an early hearing? Every bench, every decision that is not in favor of one or the other, or deviates in the way that we have been worried about the deviations that we have seen now, is critiqued not for the law or the basics or the fundamentals, but is critiqued because there is such a huge distrust of this small elite that will not allow itself to stand in front of the public and say, warts and all, here am I, but I am open. They won't do that. But they ask for the same kind of standard from the lower courts, and constantly scold, nothing more than scold like children, the lower courts or the courts below them, or say something so sharp about the judgments, etc., without going into, does this man or woman have the training, the skills, the language to be able to give? And what have we done to train him up? How did we recruit him? None of these basic things are looked at year on year on year. And as a result, there is now a fundamental distrust of the law. I'd just like to say one other thing, that, Raju, you said that, we are all imperfect. Sure we are. If you're Maja, Daruwala and imperfect, it's okay.
Yeah.
But if you are the Chief Justice, you can't hide behind the excuse of being imperfect.
Yeah.
And today we're talking about the Chief Justice, but we could easily be talking about the President or the Prime Minister or anybody else. You cannot make excuses for being less than the chair requires you to be.
And therefore, you have to be Superman or Superwoman.
Yeah.
That's a tall order.
Yeah, I think that is a tall order, and I think the fact is that it wasn't really expected of many Chief Justices of India, with great respect, whether it because it was their tenures were short. But it was certainly expected of Justice Chandrachud. Yes. And I think that's where some of this, it's a complex legacy. I mean, it defies very easy characterization to say he was like this, he was like that, which you can do actually with a fair degree of fairness to predecessors. But we have a big audience, and I don't want to monopolize the panelists here. So we will open it up for questions. So I would request you to put up your hand. There should be a mic somewhere that should make its way to you. Please identify yourself and keep your questions as short as possible. Yes, sir. There's a mic coming to you right there.
Good evening. My name is Ejaz Makbul. I am a lawyer in the Supreme Court and advocate on record only for past 40 years. And I have also seen, like Raju, Chief Justice Chandrachud as a lawyer. He had been a judge of the High Court and also in his tenure as the Chief Justice of India. I only wanted to make a small comment. You see, I have also with Raju done one of the largest litigation of this century, and that was the Babri Masjid Ram Janambhoomi case. And in that case, we had about 1 lakh pages of translations. And I remember that for doing that case, Dr. Dhawan was leading us. I used to bring my files in 5 cars. And today, thanks to Chief Justice Chandrachud, I only bring my iPad to the court. So that, and I must thank Justice Chavan. I think he has also revolutionized our this thing. So that actually the real good thing about our friend Justice Chandrachud in his tenure had been that he has really digitalized the court work. Today, in fact, many of the offices work only with 1 junior, 2 juniors, and many of our very accomplished stenographers can file. In fact, I'm sitting here and some matters are being filed digitally before the Supreme Court. So that's one small comment I wanted to make.
Thank you very much. Thank you very much. I think that's good that we've touched on this controversial case because otherwise we could be spending a lot of time on it if we get to the substance of it. Yeah, there's a question here. Could you get a mic in front here, please? I think it's on.
Hi, thank you, Argo. This is question directed towards Honorable Justice Chavan. We have heard Justice Dr. Chandrachud speak of public trust in judiciary, as in at many places he has said that judiciary derives its authority from public trust. And we also know that the strong majority in executive is also a populist expression of that public trust. So is there a tendency that maybe we have observed, not with Justice Chandrachud or with other justices as well, wherein when you see that the populist expression of public is also very strong, you sort of self-impose or self-censor yourself to sort of cater or protect the institution of judiciary itself?
A very difficult question. So first is, I believe that judges, public expectations are there, no doubt. We have to think of public trust also. But that does not mean that we have to play to the gallery as Mr. Ramachandran said. We don't have to. And then we don't have to fulfill those expectations because the fear as to how public will react to your judgment or your orders should not weigh on your mind and should not affect the judgments. Therefore, public perception, yes. But public perception does not mean that you should be deciding cases according to what public will feel. And here, I'm sorry if this is a jarring note, but Justice Chandrachud said about how history will judge him. That was a thoroughly unnecessary comment coming from such an erudite person. Okay, so believer in Almighty and all that. So we believe in karmande vadhikaraste. So you do your job, you do your duty. Don't think of what rewards will come or how people will react to it. That is not the judge's job. A judge should decide the matter disregarding how people will judge him. Because if that consideration is there in the mind of the judge, that how people will judge me in this case, like it is said that trial court judges, session judges don't grant bail or convict people because they are afraid of how higher courts will look upon them. Then if this fear is there, then you are bringing in an element of selfishness, self-interest. That is, one of the factors which weighs in your judgment is extrajudicial. It's not concerned about what is said in the case, it's about you, how people will view you. Yeah. So that is not good. That is not expected. As a sort of elder brother, I am 7 years older than him. I would say that forget about what people will think. And what people will think today doesn't make history. History will be written after 10, 20 years. So therefore, and for all of you who are sitting here, youngsters, don't ever think of how people will judge you. Do your duty conscientiously, and that's enough. Karmanye vadhikaraste, Bhagavad Gita says everything. Okay?
कुछ तो लोग कहेंगे, लोगों का काम है कहना.
सही है.
And I think I agree with what Mr. Ramachandran said, because he had actually said this to me a few days back when I was talking to him on the phone, and I reflected on this, and he had said that history will remember Justice D.Y. Chandrachud as one of the greatest judges of the Supreme Court. And at that point of time, it startled me for a moment because it was just in the aftermath of some of these comments. But the more I think about it, and I think that history will be much kinder to him than what we've seen in the last few weeks and months. I'm pretty confident of that as well. Yes, sir, there's a question there, right at the back.
I run a small paper called The Secular Savior. Now, 6 December 1992, the Babri Masjid was demolished. That time it was written in the papers, many papers commented, this is an attack on the Constitution of India. So when the judgment came, the Justice Chandrachud admitted it was a criminal act. So when it was a criminal act, the people who indulged in that criminal act, why were they given the land? Number one. And the government made it worse. The person who led the mobs to demolish the Babri Masjid, he has been given Bharat Ratna. I think it is shameful in a secular country. What do you say to that?
Mr. Ramachandran, you
Question
want
is
to?
addressed to whom?
I think you might be best placed to briefly comment on it.
Yes, having been a counsel in that case for the Muslim side with my dear friend Ejaz Maqbool, I am as baffled as you are by that judgment. This is one of the great failures of the Supreme Court, and this is one of the greatest contradictions in the reasoning of the Supreme Court. There's no running away from it.
There's a question here in front. Any more final questions? And then yeah, there are a few hands. If you could just put it up so that we can take them all together at the end. So I'm seeing 1, 2, 3, 4. Where's the fifth? 4. Yeah, I saw that. Okay. So we'll take those and then we'll stop. Yes, sir.
Mr. Ramachandran, Rajuji, I just want to know, how do you judge Justice, Honorable Justice late V.R. Krishna Iyer, V.R.V. Mr. Dhananjay Chandrachud? I don't think we had conferences like this to say D.Y. Chandrachud, the great cases and appraisal of his judicial legacy. Number two, I don't know what was his stance, and I don't think he was proactive when it came to the case of Mr. Gogoi. You know about the sexual harassment case. The bar was silent, the Supreme Court bar was not active, nor was the High Court. So where was the Justice Dhananjay Chandrachud on the rights of the women? Thank you.
Well, I'll answer the question and I will not plead out of syllabus. Now, first thing is, Justice Krishna Iyer, because I started my practice with judges like Senior Justice Chandrachud and Justice Krishna Iyer on the bench. To make a comparison is very difficult, but Justice Krishna Iyer, while on the one hand was a great judge, and I am a personal admirer of his, and I may also tell you that I've signed a contract with Jagannath to write on the 7 judges and the 7 lawyers who have influenced me in my long career, which will be touching 50 years in a year and a half. So Krishna Iyer also figures there, but Justice Krishna Iyer also was a flawed person. Distance lends enchantment to the view, but when Justice Krishna Iyer retired, there was a lot of debate. There were functions which were organized at his instance to extol him. So vanity is not a new feature. And so if you think that if your question was that no, Justice Krishna Iyer was not worried about publicity, you're totally wrong. Because I have seen Justice Krishna Iyer at close quarters, but I am still an admirer of his. And as far as the Ranjan Gogoi episode is concerned, all that I know from my memory of those times, which got clouded by COVID and other things, is that internally he did ask for transparency in terms of that committee which met, which was first one in-house committee. So I would say that he did stand up to the extent to which he could to ensure fairness in that in-house committee.
So we'll take the final few questions together. Yeah, we'll take it from you. You're in the middle. And then you can give the other mic to him then.
Hello, my name is Samir Bhardwaj. I don't have a specific question, just an observation, and sorry for reducing my observation to cricket. In cricket, whenever there is a last over, and if it's a spinner and the batsman hits, we say it's fine, spinner ko to koi bhi maar sakta hai. But when there's a pacer and people dread, but he is known as a dreadful pacer, to hit him and take the ball out of the stadium, that's something misses here.
Right, there. So
Yes, my question would be for Mr. Ramachandran,
Why are all questions going to be?
or perhaps open to the panel.
Sure, sure. Go on.
So,
ask it.
to quote Justice Chandrachud only from a few days ago, where he remarked that I have given bail from A to Z, from Anup to Zubair. Now, given the recent, status of languishing under trial prisoners, and the fact that the trial courts, talk of bail with a 10-foot pole, really, and how do you think his tenure missed the bus on making bail a more, setting a precedent where bail is a more accessible concept for under trial languishing prisoners?
Sure, we'll just take a couple together and we'll close. The lady here in black, yeah.
Good evening, I'm Garangi. I'm a final year law student. My question is to Maja ma'am. It is largely in the context of a lot of this hour was spent talking about the merit that Dr. Chandrachud held in clearing up or in bringing the technological change that he did to the court system. My question is, how much position and power does a Chief Justice really hold, and how much can be credited to the larger institution of, say, the Ministry of Law and Justice, to the several public people that are working towards that? To herald that towards the Chief Justice perhaps takes away the light and the focus on his judicial legacy and pats him on the back for an administrative legacy that he may only be a placeholder in. For you, since you have behind the scenes, to perhaps shed some insight on that, and secondly, what it means in the public eye.
And there was one other hand right there at the back. We'll just take that and we'll close there. Do you have a question as well? And we'll take the last one there and we'll close. Yeah.
I'm MD Chandra, I work for the media. Madam told that on the ground much has to be done. And Justice Chavan said that judiciary we have to do more things to judiciary, and compared to the American courts, we are just a fraction. It is totally contradicting to what you are saying. In his a sort of farewell speech, Dr. Chandrachud, in this Akashvani speech, which was delivered for 2 successive days, he quoted that our courts have become people-friendly, quote unquote, nowhere else in the world it is. How much correct he is? He specifically says people-friendly.
Right. We got that. And the last question there.
My name is Arudra. My question is to Justice Chavan. In the last few weeks, when you had a charade of criticism on Justice Chandrachud, one of the things that has been most spoken about by senior members of the bar, that in their 40-year-long career, seeing so many Chief Justices, they have never seen a Chief Justice who's spoken to the media so consistently as Justice Chandrachud has. My question is, now that you have the court having a glance that it never has, everything is live streamed, everything is reported minute to minute, what exactly would be the problem if a judge, let alone the Chief Justice of India, who's a leader of one arm of government, what problem would it have with him communicating with the media? Of course, not about cases, but just communicating with the media.
Right.
That's my question.
So we'll take that, sir, first, then two to Maya, and then the last one on bail, if Mr. Ramachandran.
See, the whole problem with live streaming is this. We embarked upon that experiment without preparing ourselves to face the camera, without preparing ourselves to, just as mic is a temptation, camera is also a temptation. So we need to train judges to face the mic and camera and then restrain themselves, because it's easy to say that court is after all open, everybody sees, everybody can record. So what is there in live streaming? What is new in live streaming? But when it is live streamed, as you say, the focus is on the court, everybody watches you. Therefore, public confidence in the system should not get shattered because of live streaming. We want to bring in transparency. But if it is done without adequate preparation, then it is disastrous, as happened in the Punjab court, Punjab High Court. See, judge said that he does not regard or does not want to follow the Supreme Court, and it went live. Thereafter, the bench of Supreme Court, Justice Chandrachud's bench, expunged those remarks from the official record. But what happened? The horse had already bolted, no? So, locking the stables after that was meaningless. So, therefore, we need to prepare ourselves. We need to miss not just judges, lawyers also need to prepare themselves to face live streaming. There are many issues about live streaming which Mr. Raju Ramachandran will be able to better articulate. See, sometimes lawyers are officers of the court. Sometimes they can say that, sir, I really don't have a case. But they can't do it now. Because, so therefore, I suppose we need to prepare a lot on this.
So Maya, the question on the administrative side and people-friendly, is the court people-friendly?
I don't know where I can give you a sort of satisfactory answer. You're right. He is the head of the administration of justice in the country. So, but operationalizing every ideal or every repair relies on budgets, on executive, on the level, on the state administration, the state's administration, and as Justice Chauhan said, the administration of the High Court itself. And we're not even talking about the district courts and the taluka courts, which I think should be the central thing that we all talk about in these meetings and gatherings, because that is where you get the people friendliness tested or not. Access, finances, corruption, all of that. How does a person at the very apex control all of this? But the expectation is that he would be able to do something about it. So he took the pathway that was available to him, which was exempling, speaking about it, to talk about the media, for instance. I frankly think the judges and all should talk to the media. But they should be careful to keep themselves within syllabus.
That's right.
You know, you don't say, I think this fellow is guilty, or I don't mind if people rape each other. You can't say those things. But you can certainly use the law and the basis of the law to create huge public education. And that in itself would be people-friendly to do so. Holding yourself aloof because the office creates a wall between you and the public. I think that is the mistake that the elite in our country, the caste, the class, they make. And if we could break that down, it would be a wonderful thing.
So, Mr. Ramachandran, the last word to you on bail, because he did make this statement that he's given bail A to Z, to which a friend of mine said A to Z, but not you. So, I mean, he wasn't talking to me, but about me. But yeah, Mr. Ramachandran.
Now, the point is, yes, as far as Chief Justice Chandrachud is concerned, A to Z. is a fact. But if there are 35 judges in the Supreme Court, there are 17 Supreme Courts.
Yeah.
So the Chief Justice's thinking on bail doesn't necessarily permeate to all the 16 other Supreme Courts. And so if Yu's case goes elsewhere, there is no guarantee that the Chief Justice's liberal views on bail go there, one. But in fairness, the Chief Justice has commented on the fact and has exhorted the trial courts not to be timid in the grant of bail. He has pointed out that trial courts prefer to leave it to the higher courts and has told them in no uncertain terms that where a case for bail is made out, it should be granted and trial courts shouldn't play safe. I think that is the most that a leader can do, and I think he has done that.
Yes, and I think we can all agree on that he has done what he thinks he could in that position. We could all have differences, we can all have expectations, but I think in that statement that my friend made, that A to Z and not you, I mean, while it may seem facetious, the fact is that we are still in a country where personal liberty is often in jeopardy. We are in a country where courts are slow and encounter killings are celebrated by politicians and the public. And of course, as one person, there is that much that you can do. And we can debate till the cows come home whether the person has done enough or not. And we can have differences of opinion on that. But I think the one thing that we perhaps shouldn't have differences of opinion on is the fact that it's us as a country that can change this state of affairs, what each of us is doing individually, whether as citizens, as lawyers, as judges, or as journalists. And I think it behooves us all to do our little bits to make sure that the justice system functions in a way in which it should. Thank you very much to my panel. This has been a really riveting discussion on a very difficult subject. To Maja, to Mr. Ramachandran, to Justice Chavan, and thank you very much for turning out on a Friday evening to the members of the audience. It was a real pleasure, and I hope that we have gotten through this subject matter in a way that, even if it may not satisfy you, would somewhat quench whatever desires you came with. So thank you very much for coming in, and good night.
Good night. Thank you. Lovely.